Good afternoon and welcome to the Alternative Dispute Resolution Certification Working Group. Please remember that the meeting will be recorded and it is now. Angela, would you please take the roll?
Yes. Armstrong, Coulter,
Present.
Curtis,
Here.
Dinkin, Dubow, Ellis,
Here.
Dr. Getz,
Here.
Taguchi, Hodgson,
Here.
Kelly, Kopaken, Cruz, Lowe,
Here.
Judge Lucky, Palevsky,
Here.
Judge Pichon,
Present.
Robertson. Robertson, I do see you. Raise your hand. Thank you. Tuckman,
Here.
Welch,
Here.
Yamshan.
Here.
We have a quorum.
Thank you. Next on the agenda is the call for public comment. State Bar staff will attempt to call members of the public in the order that they appear in the attendee pool. Angela, would you please provide the instructions?
For those participating by Zoom video, you should have a function for virtually raising your hand, the hand icon at the bottom center of your screen. If you wish to address the committee, please click on the hand icon now and State Bar staff will call on you in the order that hands are raised. For those participating by phone, you may virtually raise your hand by pressing *9. Each speaker will have 3 minutes. The on-screen timer will begin as soon as you start your comment, and you will be verbally alerted once you have 30 seconds remaining. Is there anybody who would like to give a public comment? Please use the raise hand function. Judge Pichon, I don't see any raised hands.
Okay, thank you, Angela. Next, we'll move on to approval of the minutes from the last meeting. Are there any corrections or modifications to the open session minutes? And that was from June 3rd, 2026.
I don't see any corrections, but perhaps we should note that Jill has joined us.
Thank you. Thank you.
Apologies for being tardy.
That's okay. We're good. Very beginning. If there are no corrections or modifications, may I have a motion?
I move we approve the minutes.
Thank
Dana?
you. Thank you, Ms. Curtis. Is there a second?
I'll second.
Thank you, Mr. Yamshan. Angela, would you please call the roll?
Armstrong is absent. Coulter,
Yes.
Curtis,
Yes.
Dinkin is absent. Dubow is absent. Ellis,
Yes.
Dr. Getz,
Yes.
Iguchi is absent. Hodgson,
Yes.
Kelly is absent. Kopaken.
Sorry, present.
Thank you. Jill, was that a yes to approve the minutes? Thank you. Cruz is absent. Lowe.
Yes.
Judge Lucky is absent. Palevsky.
Yes.
Robertson.
Yes.
Tuckman.
Yes.
Welch.
Yes.
Yamshan.
Yes.
Judge Pichon.
Yes.
Minutes have been adopted.
Thank you very much. Next on the agenda is my chair's report. As usual, I don't have a report, but just a couple of words, not many, because we have a lot to do today. I just want us to remember that we've all been very concerned with being as inclusive as possible so that those who aren't a part of this working group can be heard. So we have done that. We've sent out the request for comments. We got back a lot, which is great and very substantial. So we've already begun the process of reviewing the comments to our recommendations, and today we'll just continue on. So as we review the comments, I hope that we will all remember the thought and consideration given to all of the recommendation by the subgroups and as the full working group. And I want us to keep that in mind as we consider the comments and any changes that we will be making today. Also, please consider our time today. We have time constraints, and I hope that you will keep them in mind as we work through all of the comments. That completes what I have to say. Next on the agenda is the staff report.
Thank you, Judge Pichon. First, I just want to share with the working group, Katie Jones has stepped down from the working group due to time constraints and commitments. And we certainly thank Katie for her contributions to the working group. I will turn it over to Erica.
Hi, everyone. Good afternoon. We just wanted to provide you with a brief update. So for those who aren't aware, Senator Umberg introduced SB 574 earlier this legislative session. That bill does quite a few things that impact the ADR space, but we wanted to ensure that the working group is aware of one of those that impacts the certification program. As background, you'll likely recall that State Bar staff worked with legislative staff on changes to Section 6173 during the last legislative session. And those changes were ultimately enacted through SB 253, basically focused on the tiers, right? So we were looking to make some changes to clarify that additional education and training could be a basis to put someone into a higher tier. This session, State Bar staff has been working with with legislative staff on possible language within SB 574 that would do a couple of different things. Those include clarifying that complaints against ADR firms, providers, and practitioners would go through the State Bar or through a State Bar approved organization rather than maintaining a statutory path that could allow for these groups to essentially hear complaints about themselves. This is a change that was discussed quite a bit at the working group level and based on tentative recommendations that were approved by the working group. Other changes are to Section 6173 that would protect information surrounding a complaint from being disclosed. As you are all aware, the State Bar is subject to the California Public Records Act, and so any of our information that we receive is presumed to be public unless an exemption or another legal authority applies. There's proposed language in Section 6173, subsection A2, D, E, and F. And those provisions would clarify that any information provided to the State Bar as part of an ADR certification complaint proceeding would be kept confidential and private and could not be disclosed under the Public Records Act. What could be disclosed would be limited to records that do not reveal any confidential or privileged communications, including the name of the certified firm, provider, or practitioner that was found to have violated an applicable ethical standard, the action that was taken to remedy that violation, and then a very general basis upon which the action was taken. So we see this at the staff level as clarifying what could be disclosed and kind of narrowing what would be required to be disclosed pursuant to a Public Records Act request. Finally, SB 574 includes language that would create a limited exception to mediation confidentiality. This is the most controversial part of SB 574, most likely in the certification space. It would require a certified firm, provider, or practitioner, as well as State Bar licensees, so attorneys, to provide the State Bar with all requested information, records, or communications that are related to a complaint against a mediator. Providing this information to the State Bar would not waive or extinguish any confidentiality of those records. We would be prohibited from disclosing information in those records, as I just discussed under those subparagraphs I mentioned. Staff has been working with other legislative staff on this to basically try and provide us with tools to be able to actually address complaints in this space. This is really modeled directly on Rule of Court 3.871, and it provides a limit to what can be disclosed after the complaint was resolved, as I mentioned, but it does allow us to, what we think is to better properly investigate complaints. And so this is kind of the language that has been proposed. Now, as you've seen on today's agenda, SB 574 is not agendized for today or tomorrow's discussion, but we just want to bring this to your attention. And then I also wanted to make sure that you're aware of an avenue to provide public comment essentially on this if you disagree with staff's recommendation in this space. So this coming Thursday, the 16th, is the State Bar Board of Trustees meeting. As part of that meeting, SB 574 is agendized as part of item 6.10, which is the State Bar's legislative priorities item. And what will happen at that meeting is staff will be asking the board to take a high-level support position on these provisions I just described in Section 6173. On the other portions of that bill in SB 574 that address artificial intelligence and arbitrator use of generative AI, and those types of things. We are not asking for the state bar to take a position on it. We're proposing a no position on that. But if there is any concern or other information that you want to express to the Board of Trustees as it relates to the provisions I just talked about, you can certainly do so by providing written public comment to the board that gets distributed to the board in advance of the meeting. And then at 11 o'clock on Thursday, the 16th, there would be an opportunity to provide up to 2 minutes each of public comment on this item. So just wanted to make sure that the working group is aware of that, and thank you.
Thank you very much, Ms. Doherty. Any questions? All right, then thank you so much. We will now move on to the business portion of our meeting today, and we'll begin with the status report on the day of court community-based mediator subgroup presentation, and it will be presented by subgroup lead Dana Curtis, who will provide a brief update on the first meeting of the subgroup and the next meeting. This is for information only, and we don't anticipate a discussion on it. Of course, if you have questions, you may always ask them. Thank you so much, Ms. Curtis, for taking this on. Really appreciate it. Would you please proceed with your presentation?
Yes, you're welcome, Judge Pichon, and thank you. I wanted first to let you know who all was in the subgroup, and that's Sarah Hodgkins, Chris Welch, Daniel Yamshin, Ron Kelly, and I. Also attending the meeting were Mia and Alan. We met on June 12th and began by reviewing the comments that were made during the meeting and also the public comments that we had been discussing. And we also then took time for each person in the room to talk about their own perspectives on the issue and some of the concerns that they might have. And then we had a very robust and interesting conversation about the interests that were at stake in really moving through our task to develop qualifications for a path that could permit day of court mediators to become certified. So we laid a lot of groundwork, and then our next meeting will be August 3rd. And at that meeting, we'll begin looking more deeply at those interests and discussing them more and beginning to develop some framework for the path and hopefully get to some solutions. But we'll report our progress at the working group that follows our August 3rd meeting. Thank you.
Okay. Thank you so much. And Mr. Yeah. Okay.
Are you ready for that? I'm sorry, I thought I might have jumped the gun on that.
No, that's just fine. That's where we're going.
Okay.
So now we'll move on to the proposed new state bar rules, standards, and policies regarding alternative dispute resolution program, the return from informal public comment, and the request for approval of the working group recommendations for submission to the Board of Trustees as appropriate. And we're going to start now with the appendices that we told you by email so that you could be prepared for today. I know even though we did limit it to 4, it was still quite a bit of work. So we will start now with Appendix A. And for Appendix A, there were 86 narrative comments about the tentative recommendations in Appendix A. They were submitted by 20 individuals or organizations. Because paths 1, 2, and 3 of Appendix A specify a number of required qualifying arbitrations, we thought it might be helpful to address the definition of a qualified arbitration first. And this is covered in the request for comments A11. So the working group's recommendation is qualifying arbitrations must include a contested hearing with at least 2 hours of live testimony and result in a reasoned written award, which may be an interim, partial, or final award. 4 commenters agreed, or 4 commenters indicated that they agree with this definition. 1 indicated that they agree only if modified, and 8 indicated that they disagree, and 5 had no position. Concern for the comments were as follows. I'm going to go through them all, but I'll try to do it very quickly. But the comments on qualifying arbitrations definition were a concern for a requirement of reasoned awards because some parties don't want them. Too much weight is given to live testimony. Too much weight is given to simple arbitrations, which can be completed quickly versus complex ones and long arbitrations. Consideration should be given to the number of hours presiding over an arbitration, regardless of whether it resulted in an award. This comment was the definition of qualifying arbitration will constitute a real barrier to entry and stall many practitioners from becoming certified who are otherwise well qualified. It will become the litmus test for the state bar certification, and it is likely not the right one. Arbitrators with full caseloads often do not get 3 qualifying arbitrations in any 2-year period because the vast majority of cases settle. A substitute for qualifying arbitrations that does not constitute such a barrier could be the number of arbitral selections or appointments a practitioner receives. The working group should consider what number of selections or appointments within a 2-year period could satisfy the experience requirement. Okay, those are the comments that they received. So I don't want anybody to feel left out who did submit comments. So based on the comments and your review of them, the question to you now is, does the working group want to make any changes in the definition of qualifying arbitration?
I see Dr. Getz and
Oh, yes, Dr. Getz?
Well, thank you, Judge Prashant. And I think part of that was inspired by my comment. So I just wanted to have the opportunity to elaborate a little bit more. I'm really concerned about this definition because I believe it could end up having a state bar certification that doesn't really reflect what's going on in the marketplace. It wouldn't, and it might lessen the value of the state bar certification. And let me just try to as quickly as I can, elaborate on it. I've served on 2 arbitration panels over the last 18 years, very different panels. One would be FINRA, which is securities regulation. Another would be the LA County Bar Association attorney-client fee arbitrations. For FINRA, I've had 71 cases in which I've been confirmed as an arbitrator. That means that 2 parties with skilled attorneys on both sides have reviewed my background and then selected me above others. So both parties think that I'm capable of rendering a decision. Having said that, in the FINRA environment, out of those 71 cases over the last 18 years, 2 actually would qualify as an arbitration under this definition, mostly because FINRA does not require reasoned awards unless the parties specifically request it. So my main concern here in relation to the FINRA panel is there could be a lot of other panels out there like FINRA. I mean, Mr. Tuckman, others represent panels. I don't have the experience necessarily beyond my 2 experiences to tell you, but I'd be concerned about us eliminating a lot of very qualified arbitrators who are qualified otherwise. In other words, they've gone through the rigorous training, and we have to believe, and I think when we get to the training, we'll see that we've required more rigorous training than perhaps the marketplace has demanded to date. So let me compare that just for a second with my experience with the LA County Bar Association, the attorney-client fee arbitration panel. So again, 3-member panel. There you're selected, but you're selected by the county bar. So the parties don't participate in the selection process. They have to accept you. In both panels, only the chair really writes a reasoned award when it happens. So the other two arbitrators are, yes, they can participate in the drafting, but they don't have to participate in the drafting. It's basically the chair. So in my LA County Bar Association arbitrations, which I've done 36 of those, in fact, most of them do have reasoned awards. So I could qualify based upon that experience, but I would suggest to us that the marketplace may not really support what our quality certification says, because in one case, let's say you're the third arbitrator, you're one of the other two, not the chair on the FINRA panel, you're probably not participating in the reasoned award. Same thing with the LA County Bar Association. You're not really participating in the reasoned award. So we're actually allowing this, if this certification went through, someone from the LA County Bar Association panels who have not been selected by the parties, but has rather just been selected by the county bar, who's a third person on that panel or one of the members of the panel that's not the chair, would have the experience over a FINRA arbitrator who perhaps is pretty well seasoned and knows, for whatever it is, security regulation law pretty well. But again, would not have had a reasoned award. So ultimately, I think the quality associated with our certification may not be the quality that we really want associated. So I posit that as one reason. Second reason I don't like this definition is that many arbitrations obviously settle along the way. And so few actually get to the arbitration stage. The fact that I've only been on 71 over 18 years in FINRA tells you a little bit about that, because there's been a lot more that where I've been perhaps confirmed, but never have seen the hearing day. So one of the things about a certification from my experience at MC3, people need to plan. So a practitioner needs to plan how they can actually apply for something that they want. They're going to want our certification. They're going to want to apply, right? Well, for the most part, when you want to be an attorney or you want to be an accountant or you want to be a doctor, you can sit there and plan the steps. Here, it would be almost impossible to plan the steps because you never know whether an arbitration that you've been selected for would actually result in going to a reasoned award. So, and have 2 hours of live testimony, even if it didn't go to. So I recently had a reasoned award that was settled on motion. There was no live testimony. So that wouldn't even qualify. So I would just say we may find ourselves in a position, if we push this through, for certification that's not reflective of the marketplace. And also, we may be back here in a couple of years analyzing why we have so few people applying, because they couldn't fit within the definition of it. And so, again, I would throw it out to the group, and I hope we get other comments on, from others who are involved in panels and whatever. But I would think this would be something like we did with the court mediators. This was something that should go back for some rethinking. The rethinking that might have to be done, whether you serve as a chair or whether you serve as just another member of the panel, might be a distinction we want to acknowledge. We might want to rethink whether someone who's just appointed, as opposed to having a selection process with the two parties, whether that should be something that is part of it. And ultimately, I think what we really want to get to is not have people dependent upon applying for certification depending upon the outcomes of their arbitration, but rather the fact that they were selected and confirmed, and trust our training process that we've ascribed here in the certification program. Thank you for hearing me out on this.
Okay, thank you, Dr. Gadd. Mr. Yamchan?
You're muted.
Thank you, Judge Prashant. I'd like to back up Jack's arguments and give a couple of different reasons. In the 1990s, reasoned awards were much more common than they are today. And I think one reason why parties request them less and less is because they simply don't want to pay for it. You're paying an arbitrator's study time for writing the award. And if they can avoid that, they will. I think another reason is because a reasoned award will rarely do them any good because of the very, very narrow grounds for vacating an arbitration award. Mistake of law, even manifest disregard of the law, those aren't grounds. So the reasoned award, really, the only value it would have is for a lawyer to explain to the client why they didn't prevail in the case. And usually the lawyers can explain it pretty well, because by the time you're done with the hearing, you know what the evidence is, and you know what the credibility of the witnesses are, et cetera, et cetera. So I think the trends that I see is based on an experience different from Jack's, but I think it supports his position that requiring a large number of reasoned awards within a specific time period could be very counterproductive. And thank you.
Thank you, Mr. Yamshan. Mr. Weiner.
Thank you. I appreciate the concerns that both Dr. Getz and Mr. Yamshan, as well as the commenters, have raised. I also have a concern about the public perceptions of the program. If a party is going to an arbitration, particularly somebody who's maybe more in the consumer ilk than in the frequent flyer ilk, and their expectation of arbitration is that it's a process that results in a written award or a written decision by the arbitrator. And the state bar is certifying arbitrators who have never or rarely performed that function. It seems to me that that's problematic. So I'm wondering whether there might be an easier way. I appreciate Dr. Getz's suggestion that, maybe this should go the way of the day of court program and be sent back for further study. But I wonder if changing reasoned award to a reasoned decision might address many of the comments more expeditiously and also effectively than going back to, for further study. I'm recalling back to the arbitrator subgroup that had a lot of discussion about this. And, several of the members of that subgroup are here today. And it was considered important that arbitrators have performed sort of the core functions of arbitration. And that's why the definition came up, included a contested hearing with at least 2 hours of live testimony, and resulted in a written award. Really, the interim, partial, or final award was intended as an accommodation to the recognition that often there are not, final awards at all, because maybe after the parties receive an interim award, they read the tea leaves and settle the case. So I'm just curious whether there might be a simpler solution, like changing award to decision.
Thank you, Mr. Weiner. Ms. Hodgson?
Thank you, Judge Pichon. I wanted to clarify because I am having a hard time, I think, grappling with the difference between the discussion we had surrounding, for example, day of court mediation and the qualifications relating to mediators in that space, and the arbitration qualifications that we're discussing now. And I thought we had some really robust discussion with respect to mediators and day of court mediators, and obviously that discussion is ongoing in our subgroup. But I'm hoping that someone can help me better understand the distinction between the desire to lower what I understand to be lower qualifications that were previously agreed upon for mediator or arbitrators as opposed to the mediators.
Mr. Yamcha, I see your hand is up.
Thank you. Sarah, regarding your question, I'm just going to guess is we are responding to written commentary. And so the original recommendations, as far as I understood, were not considered to be final because they would be subject to public commentary and amendment or modification. Alan, I have to ask the distinction between a reasoned award and a decision. Now, if a standard arbitration award with win-lose, here are the damages, and in some cases, whether there's fees and costs awarded, if that counts as a decision, I'm fine with it. But I just want to make sure that I understand because, Jack raised some very important issues. I'll give you an example. I'm in the middle of a $250 million arbitration, 20 lawyers in the room. We're on a 1-week break now. We'll have a total of 6 weeks of arbitration, and the paralegals and all that. And during the preliminary conference, they specifically stated they do not want a reasoned award. Now, I'll be very frank that I'm going to have to write an award that won't be served on the parties just to work through the complexity of the case, because it's not the kind of situation that can be decided with a thought experiment. So the parties will not be served with a reasoned award. It would not count under the current schemata, but it would happen anyway just because of the size and the complexity of the case. So I think if decision means a standard award that's a written award that names the damages and deals with issues of fees and costs if they exist, then I would be comfortable with that.
Thank you, Mr. Yamcha. Dr. Getz?
Thank you, Judge Prashant. So in trying to answer Sarah and Alan, and then maybe go through it, I mean, I think the commonality here, Sarah, for you is that the majority of people who chose to comment on the definition of qualifying arbitration were opposed to the current definition as written. I think we saw how we honored public comment with the court mediator. So I think that's part of the impetus of this. For Alan, I would just suggest the following, that unless we're going to make a distinction between the chair and one of the other members of the panel, the certification, the fact that someone sat on a panel that ended up with a reasoned award who had nothing to do with writing the award doesn't give any greater assurance to the parties that that person has capabilities. I think you're going to have to ultimately rest on the training qualifications, which again, I think we when we get to that, we'll see that we've probably set those higher than what's considered the regular in the marketplace right now. But in any event, we can go back and forth on that, and I'll leave that for that discussion. But that's the reason I would say it doesn't. Our certification will not provide any greater assurance that that person who's certified can write the reasoned award just because they sat on LA County Bar Association or other county bar association panels that have where the chair's written the reasoned award. Thank you.
Okay, so Mr. Weiner, you'll be the last person, and then I think we're going to have to make a decision on how to handle this. So,
Sure. Yeah, just briefly, I wanted to take another stab at answering Ms. Hodgson's question. And I think your question might be, well, why would we handle this differently? We sent the other to a subgroup, and we're talking about, or I was suggesting in particular, maybe it's not necessary to send this back to a subgroup. In my mind, the distinction is whether there's a solution that can be readily, an effective solution that can be readily and quickly reached in this group. For example, if changing award to decision would do that and everybody says, yes, that solves the problem, then I would think that that would be a reason for treating it differently from sending it back to a subgroup as was done with mediation. So that was my view on the difference in making that suggestion.
Okay, thank you.
Okay.
Mr. Yamchung, anything new?
Yeah, I just would like clarification. Alan, decision would mean a standard award.
I think decision would need to be defined. When you commented or raised your comment, the question that raised for me is, okay, well, an award is a known commodity in the arbitration industry, and that decision might take some more definition.
Okay, all right, thank you. So now I'm going to go to the group. Since decision would need to be defined, it's not something that we can do today. So if the members of the group support Dr. Getz's position or would like to discuss it, then I would just like for a motion to take this recommendation and send it back or develop a group to consider it. Either we go with what we've already written for the definition of qualifying mediations, or we want to consider the recommendation made by Dr. Getz. Dr. Getz?
Yeah, I will make a motion that we form some sort of task force to consider the definition of qualifying arbitration based upon the voluminous public comments we received on that point and the comments made at this meeting.
And I will second it and note that the task force can be comprised of the original arbitration subgroup.
Judge Pichon, if I may, as we did for the last working group for the day of court, appreciating the motions, we don't necessarily need a motion to go back to a subgroup if that is what the working group prefers. We can do that, and we can create another subgroup, or I suppose reconstitute the last one. We don't need a formal vote on it, even though I know we have the motions.
All right, then I'll just ask, is there any objection to this process? Okay, hearing none, that is what we will do. So what is the appropriate wording, Ms. Mia Ellis?
Well, I think Mr. Getz, and I think it was Mr. Getz, Dr. Getz, pardon me, should withdraw his motion, just for the record.
Oh, okay.
On advice of counsel, I withdraw my motion.
In writing.
Okay, all right, then the matter will just be referred to what, subcommittee or?
Yes, we'll have to work to, as we did before, create a subgroup. And we can talk within the chairs and advise the working group.
Okay, then that is what we'll do. All right, that will take care of qualifying arbitrations, the definition. So with that, oh yes, Mr. Weiner?
I was just going to say, and I may be jumping 2 steps ahead here, but I think it may be important to table the discussion of the number of qualifying arbitrations that are required for certification until that is defined, because a more rigorous definition of qualifying arbitrations may suggest a lower number being required, and a lower bar, if you will, may suggest requiring a higher number.
Okay, that is the number of qualifying arbitration does appear in path 1, path 2, and path 3.
So I think, for example, the working group could go forward in discussing the training requirements. They may not be as closely linked to the number of definition and number of qualifying arbitrations, although the group may end up concluding that they are. In the case of mediations, we ended up basically tabling the full discussion because of the link between the definition of qualifying mediation and the 2-hour limit particularly, and the reconsideration of that issue.
All right.
The others.
Mr. Weiner, are you suggesting then that we go ahead with the paths and discuss everything but the number of qualifying arbitrations?
I think the group could go ahead and begin discussing that, and hopefully won't find itself in need of an answer to the definition of and number of qualifying arbitrations to move forward.
Okay, well, let's see how
Let's
we
try.
All right, we'll see how we do. All right, so we're going back up to the beginning now, and we will go to path 1, which is without admission to practice, a JD or a conflict resolution degree or certificate. At least 24 hours of basic arbitrator training within the 2 years prior to applying for certification, including at least 2 hours covering the Judicial Council ethics standards for neutral arbitrators and contractual arbitration. If basic arbitrator training completed more than 2 years prior to applying for certification, at least 8 hours of continuing or advanced arbitration training within the 2 years prior to applying for certification, including at least 2 hours covering the Judicial Council's ethics standards for neutral arbitrators and contractual arbitration. And then the last one deals with the qualifying arbitrations. Now,
If I
yes.
Can I just make one clarifying comment? So just as a reminder, the at least 8 hours of continuing advanced training within the 2 years prior, if the basic training was completed earlier, that's essentially saying that they need to have completed what would be the continuing training requirements ongoing. So this is essentially the continuing training obligation, 8 hours every 2 years. And so this is basically saying if the basic training was longer than that, then they need to have completed what the continuing training obligation would be.
Okay, thank you. Ms. Ellis?
Judge Bichon, I don't know if this is the correct time to make this comment, and it's quite a global comment, but I've been thinking on the fact that we're on these 2-year cycles for both mediation, training, and experience, as well as arbitration, and comparing that to the application cycles of 3 years. And so it's just been on my mind that we may want to consider putting those in better parity. In addition, if you're looking, and I know, again, this is not specifically to do this part 1, but there's things that the mediation subgroup put together that I thought were really thoughtful, including an inactive status option for mediators, as well as qualifying mediation activity. And those are concepts that we don't see in the arbitration appendix. So a lot of big thoughts, but I wanted to throw them out as we continue the discussion here.
Okay, thank you. Good point. All right, let me run through the comments, and then we'll have discussion about how you want to attack the wording that we have chosen. The comments were, this process exceeds the requirements of the statute and will result in practitioners choosing not to be involved in this process. The next is, what does the training consist of? Next, lack of training programs providing 24 hours of arbitration training. Next, State Bar should be responsible for this training and it should be affordable to all. And next, there needs to be criteria developed for the trainers. The others all relate to the number of qualifying arbitrations. All right, based on those comments and the comment of Ms. Ellis, what would you like to do regarding the wording of path 1? Do you want to make changes in what we've stated in the recommendation? Ms. Ellis, do you have suggestions as to how your suggestion might fit in?
I would recommend that whatever we decide to do, we should try to get these paths all on 3-year cycles so that it's easier to evaluate as a part of the application and recertification process.
Okay.
We could do this purely mathematically for the continuing. And then I do think otherwise it would be nice to see the inactive status concepts moved over from the mediation appendices. And then finally, I think this question of whether we would want to work with the concept of qualifying arbitration activity would be great for any newly formed or reconstituted subgroup to discuss.
Okay. So the question is, Ms. Ellis, how does that fit into the wording? The 3-year cycle versus the 2-year? How would that change our wording?
For the first bullets, and the amount of basic training for path 1, for example, I would just simply change it to 3 years instead of 2 prior.
Okay.
And then I would defer to discussion of the group in terms of whether to make it 8 hours continuing over a 3-year period or perhaps 12 hours continuing over a 3-year period.
Okay, so the first bullet has the 2 years prior, so you would change that 2 years to 3. And the second bullet, would that 2 years also change to 3?
Yes.
All right. And then the third bullet, we won't be discussing today because that's qualifying arbitrations. All right. What other change are you recommending? Say in bullet 1, would that be the only change?
Yes, that would be the only change.
Okay. And in bullet 2, what would that be the only change in bullet 2? Because you mentioned 8 hours versus 12 hours.
I would propose that the only change would be the timing, but I would be curious to have discussion on that if others are interested.
Okay, great. All right, so we have your suggestion, and that's in path 1, just changing the 2 years prior to applying to 3. And the second bullet, basic arbitrator training be completed more than 3 years rather than 2. And those are the only changes that you have suggested.
As to the bullets shown in path 1, yes. Thanks, Judge.
Yes, yes. As that's the 2 bullets in path 1, the 2 first bullets. Right?
Yes.
Okay, perfect. All right. Anybody else? I don't see any hands. Okay. That's, you want to move that, Ms. Ellis?
I defer to staff. I know that there was an interest in moving an entire appendix at once, which I know would be a little stymied by the new subgroup.
All right. Yes. Staff, would you prefer to wait, or would you prefer to make these changes as we go through them and the group agrees to them?
My recommendation would be, since part of it is being deferred, if we're discussing them now, I think they should be, it would be helpful to vote on them as they are approved by the group. Now, it may be that we could go through and do the same thing with path 2 and just defer the bullet relating to qualifying arbitrations, and likewise with path 3, and then maybe save the number of roll calls required.
Okay.
Miss Mia Ellis, what do you think? What's your preference?
Yeah, well, I think if we could get through the other part of it and still vote today, that would be ideal. I do also just want to point out if Ms. Ellis, the second bullet, the second line has another 2 years. I'm assuming that should be changed to 3 as well. It's still. Oh,
Yes,
Ellen.
I mean, would it be helpful to just to do an informal straw poll and see if the group at large is in general agreement with this concept?
Well, we just did that. They said, okay. They didn't say anything, but
Right. But yes,
the
Ms.
question.
Mia Ellis, I agree for
Okay.
that one.
It-
All right.
yeah, it's that one, Ellen, right there. Yes.
Great. Thank you, Mr. Weiner. Appreciate it. All right. Let's move on then to path 2. Path 2 is with admission to practice, JD, or conflict resolution degree or certificate. The bullet is at least 8 hours of basic arbitrator training at any time. The next, at least 8 hours of continuing or advanced arbitration training within the 2 years prior to applying for our certification, including at least 2 hours covering the Judicial Council ethics standards for neutral arbitrators in contractual arbitration. And the last we're not discussing at this time. The comments are the recommendation ignored experience and does not consider the experience of civil trial judges. The recommendation requires competencies over the purpose of the legislation, which is ethical practice. Make the distinction between arbitrators who have been admitted to practice with less than 3 years of experience and those with more years of experience. The next is the cart has been placed before the horse because there is a lack of available programs providing 8 hours of training. State Bar should be responsible for providing training and the programs should be accessible and affordable. The next is 8 hours of training is not enough, especially with 2 hours devoted to ethics. This person recommends 20 hours of training, whether or not they have a JD or a CR certificate. Staff has a position. Staff, I'll be happy to state it if that's okay with you.
Thank you.
Okay, staff tends to agree that 8 hours of training is not sufficient for arbitrators qualifying under Path 2. It is possible that an arbitrator might be admitted to practice or attain a JD or a conflict resolution degree without taking a basic arbitration training, in which case 8-hour training would appear insufficient for the State Bar to certify the practitioner to conduct binding arbitrations. And if the arbitrator has taken basic arbitration training as a part of their JD or conflict resolution studies, they would be able to satisfy the 24-hour requirement, Path 1 training requirements. The next one, I read the longer version of it. This is the shorter version. Redefine qualifying arbitration. Consider the number of arbitral selections or appointments a practitioner receives. Okay, those are the comments. What, if any, additional changes would you like to make to Path 2? Mr. Palevsky?
Just a clarification. The 8 hours of basic training plus 8 hours of continuing within 2 years sounds like 16 hours to me. Is that right?
8 hours of training with 2 years prior.
Yes, I think that was the intention of the arbitrator subgroup. Is that, there would be, I think in the definition, if you'll pardon me for scrolling down, I think the definition talks about what the 8 hours of basic training needs to consist of. And there was even a subgroup that Mr. Yamshan, I recall, was a member of, that talked about what should be covered in each of these trainings. So the idea is that there would be, the 8-hour basic training would cover these sort of basic facets of conducting an arbitration. And so if the 8 hours was taken 8 hours of basic was taken by somebody who has a JD this year, or within the, I think what may become a 3-year period, the 2-year period or 3-year period, they would also need to take the 8 hours of continuing or advanced. If the 8 hours was conducted more than the 2 or 3 years before, then they would only need to take the 8 hours of continuing or advanced.
Okay, thank you, Mr. Winger. Ms. Ellis, let's see, Dana Ellis, is your suggestion the same for the second bullet? Making that 2 years to 3?
Yes, Judge Pichon, it would be the same.
All right. Are there any other suggestions with respect to the first 2 bullets of path 2? Oh, yes, Mr. Tuckman?
Yeah, just I'm recalling some discussions a few months ago that were had about training and what impact that would have on the number of people that might become certified arbitrators. And just I think based on some observations, at least was it the AAA, which required training and some continuing training. It can be difficult. It can be difficult to get people who are qualified, who are good arbitrators, to go through training. And what I'm getting at is sometimes the types of people that you would want to be part of the certified arbitrator group are the types of people that are going to say, look, I've already got CLE requirements. I'm already, certified as a other type of practitioner within the state. I've already got training requirements as part of other groups. Cumulatively, it can be a barrier to some of the more qualified arbitrators engaging in additional training. So I do understand that certification, this comes up time and time again, that it needs to mean something. The state bar, if they're handing out the certification, needs to be meaningful to the consumer. But I'm not sure just adding additional hours here is necessarily the answer.
Okay. Necessarily mean, Mr. Tuckman, that additional hours are required. The CLE and others, maybe one of those programs would qualify with this training.
I think the discussion is that they wouldn't. Maybe that's something that would be helpful to clarify. If it does, that I think relieves some of the burden.
Okay, all right. Thank you, Mr. Yamsham.
Yeah, Eric just raised an important issue because most of the providers require training annually and typically, some more often than that, but they're not MCLE trainings. They're trainings designed for that provider. And I think I never thought about this before, but I think it should be important that even though for lawyers continuing education, they wouldn't count, but it would be important to let them count for neutrals.
All right, thank you. And don't forget, we're going to come to what the training should consist of. We just haven't got there quite yet. It's at the bottom of what we'll be discussing. However, Mr. Tuckman, do you have any suggestions for our language that we have proposed?
I don't, off the top of my head.
Okay, that's fine.
And are you saying, presuming that we would have additional training, or I think I'm more inclined to leave it as it is probably my position.
Okay, thank you. Anyone
I could ask for clarification of Mr. Tuckman. When you talk about your concern about the additional training or about the training, is that addressed to any of these particular requirements? Are you talking about the 8 hours of basic? Are you talking about the 8 hours of continuing? Are you talking globally?
Honestly, I'm talking globally. Thank you.
Okay, that's great. Okay. Ms. Jenna Ellis.
Thank you, Judge. I'll just add as another global comment, and I think this somewhat dovetails with Mr. Tuckman's comment, but it's another one that's difficult to place. I want to amplify the comments discussing retired judges and their experience. And I don't know if this is a path with regards to amount of training or if it's something to be discussed by the convening subgroup. But I do think it's an important thing to keep in mind and goes to Mr. Tuckman's point that, you know, those are very qualified professionals who, you know, we would like to see participate in this program.
Thank you. And I think I saw one more hand. Okay, I don't see any other hands. So my question to the group is, there's just one suggestion regarding this wording for the first two bullets of path 2. You want to proceed on with what we have, making the change in the second bullet to 3 years rather than 2 years? Do you want to proceed on? Does anybody object? Okay. All right, Mr. Weiner, you've made that change and we'll continue on. So next we'll go on to path 3. Path 3 is experienced practitioner without basic arbitration training. And the bullets are 1, at least 8 hours of continuing or advanced arbitration training with the 2 years prior to applying for certification, including at least 2 hours covering the Judicial Council ethics standards for neutral arbitrators in contractual arbitration. And then the next, we are not discussing today, that's referred back. The comments were, consider the experience of civil trial judges. The next is focus should be on ethics as required by the statute rather than competency. The next is 20 hours of training should be the baseline requirement for all paths. And the last one is redefine qualifying arbitration, which we're not discussing now. So I'll go back to Ms. Jenna Ellis. There you are. Do you want to make the same recommendation on the first bullet?
Yes, Your Honor.
Okay. All right. Are there any changes that would be suggested in path 3 in addition or deleting what we have proposed? Okay. Okay, Mr. Yamshan.
Okay. I should almost apologize for having spoken so much today. I think this may have been raised before, but shouldn't providing training, being a trainer, count for training experience? That's my question.
Okay, that would be an additional. We'll just make a note that you said that. So being a trainer. Okay.
It should count for training experience, and then that raises the issue. If you're an MCLE presenter, you get 3 hours of MCLE credit for every hour of presentation that you actually make. If you're on a 1 hour panel and you give a third of it, then you don't get 3 hours, but you get the proportional time. And so it does raise the question of how much credit do we give for being a training provider.
Okay, all right, thank you. Mr. Weiner?
Yeah, if I could just quickly address that, there is tiers credit given for the higher 2 tiers for providing training. And I think that was sort of the way that this was handled. I think I do recall the discussions that you're referring to, Mr. Yamshan. And, you know, I think part of my perspective, at least, was that in addition to giving training, perhaps sometimes giving the same training repetitively, it's beneficial for practitioners to hear what other people have to say.
Right. Okay.
And so I guess I thought that it was a good balance of interest to have. You take some training and you can get tiers training for providing training.
Thank you.
Okay, thank you. Mr. Palevsky?
We don't have a definition of advanced arbitration. training. I wonder if that would be helpful.
We haven't come to that yet. I
Well,
think
it's in,
we're going to come to that.
that's in path 3.
It will be under what the training consists of, but if that's not sufficient, when we do get there, let me know, okay?
Sure.
Okay, Ms. Copaken?
Yeah, similarly, and I apologize if I missed this, but experienced practitioner, I don't know what that means. I would heartily second what Ms. Ellis said about judges. I think we want to acknowledge that folks who are coming off the bench have, have significant qualifications here. And I may have just missed what experienced practitioner means, but relatedly, I see Alan has his hand up, so I probably missed it.
If I can just quickly respond to that. So the idea, this heading, experienced practitioner, is just sort of shorthand for what the requirements are. And essentially the requirement is that they've done 12 qualifying arbitrations. So whereas others would have done 3 or 6 arbitrations, they would have done 4 or 2 times that number. That was what was meant by experienced.
Dr. Guest?
Yes, just a slight clarification. I think in path 3, the modification we wanted to make from 2 to 3 was in the years and not the hours.
Thank you.
Yeah, right. Thank you. Let me see, any other hands? All right, so far what we have is the 2 years to 3 years and being a trainer, and also consider the experience of civil trial judges. So going back to the group, do you want to change the language that we have here?
Judge Bashan?
Yes. Oh, yes.
If I may, I'd just like to make the suggestion that the group that's going to be talking about qualifying arbitrations also consider the question about prior judicial experience, because I think there are a number of nuances to that, whether serving as a pro tem, whether a person needs to be officially a retired judicial officer, whether they need to have had any civil assignments. So I think there's some further discussion of those questions
Okay.
that would be helpful.
Okay. All right. So before I ask the group if they'd like to just send that back, consideration regarding prior judicial experience, what about experience as a trainer? Do you want to send that back also for discussion?
I would vote to send it back, yes.
And that was Miss Alice. Okay. Would anybody oppose that? Okay.
No,
Then,
Judge Bashan, I'm not opposing it as a member of the working group, but I'm just suggesting that this is perhaps an issue that's been, that was vetted. It was discussed during the subgroup meetings. As I mentioned, it was kind of addressed in the tier structure, and just in the interest of not perhaps unnecessarily visiting comments, especially those coming from working group members, not from the public commenters, that the group consider sticking with that decision that was made previously.
okay, well, let me just ask the group then. Are you satisfied with keeping the language that we have, rather than at this particular time trying to add in prior judicial experience and experience as a trainer? Is there anyone opposed to keeping this language that we have, and then later on, or if you feel it's important, find a way to consider prior judicial experience and experience as a trainer, but not trying to insert it here? Okay, I'm looking at everybody. So I think everybody's okay.
No,
with just,
I see,
oh, I'm sorry.
I see Ms.
Hodgson and
Hodgkin.
Ms.
Oh,
Ellis.
Ms. Hodgkin, I'm sorry.
Oh, no worries. It's hard to see people with the screen share, which I do appreciate the screen share. I just want to clarify, is the intention to address, for instance, prior judicial experience at some point in the future of this particular working group, or to leave that silent and see what happens after the working group ends its work?
So may I again, Judge Bashan, just to clarify what my suggestion was that the prior judicial experience question be considered by the group that's going to consider the definition of qualifying arbitration, and that the question of receiving baseline certification credit for training be left as it is, and with no credit in baseline, but credit in tiers, rather than being sent for further study. That was my proposal.
Okay, so Ms. Hodgkin, are you okay with that? It would be that the trainer aspect credit for that would come within tiers. But as far as prior judicial experience, that would go to the group that's considering that's considering the definition of a qualifying arbitration. Is that okay with you?
I think so. I'm happy to hear that the prior judicial experience will be addressed and more fully discussed at the subgroup level. And if I'm understanding Mr. Wiener's comments correctly with respect to credits, I'm using air quotes here, but credits for training as a trainer, that has already kind of been discussed and decided. We don't need to kind of reopen a can of worms that we sealed up nicely before. And if my understanding is correct, I'm cool.
Okay, I believe that to me sounds like what Mr. Wiener said.
Thank you.
But great, thank you. Okay, so we've made that one change in path 3, and now we'll move on to the next, which is recertification all paths. And that our recommendation is at least 4 hours of continuing or advanced arbitration training per year, including at least 1 hour covering the Judicial Council ethics standards for neutral arbitrators in contractual arbitration. And then the second one deals with the number of qualifying arbitrations. Okay. The comments that we received were redefine what a qualifying arbitration is and consider appointments and selections as an arbitrator. The next is, it deals with the number of qualifying arbitrations. And then the next one is, what does the training consist of? No explanation of when certification is required, nor does it explain what years are covered in the requirement of training hours per year. Based on those comments, does the group wish to make changes to our recommendation? I don't see any hands. I'll tread lightly here to make sure. Okay, well, that means that this recertification is going to stay worded as we worded it. Okay, all right, let's move on. Now we're at the bottom. We're going to skip over qualifying arbitrations, Mr. Wiener, and go to 24 hours of basic training. Yeah, 24 hours of basic arbitrator training must include the following topics. And then I'm going to skip over and see where the comment. Oh yeah, well, I'm going to have to take them as a whole in order to give you the comments. Okay, so we've got what we've suggested as 24 hours of basic arbitrator training must include the following topics. And you have 14. I won't read them because you have 14 there. And then the next one is that 8 hours of basic arbitrator training must include the following topics, and there are 9 of those. Then we go down to the JD doctorate, the Juris Doctorate, must have been earned at a nationally, regionally, or state bar accredited institution. The graduate degree in conflict resolution must have been earned at a nationally or regionally accredited institution. And then conflict resolution certificate must have been earned at a nationally or regionally accredited institution and must have consisted of at least 12 semester units certificate covering conflict resolution theory and practice. Okay, the comments are consider the experience of the civil trial judge. Okay, we're going to do that. The next is the legislation is designed to encourage ethical behavior, but the training it lists ethics as only one of 14 subjects. The next is a JD or graduate degree should not be required, but if they are, there should be years of experience and training equivalencies. Basic arbitrator training should be at least 20 hours and consist of the same elements as required for Path 1. Certification should prioritize experience and subject matter experience over a Juris Doctor degree. Should include degrees earned internationally. Experience and training should be accepted as equivalent to a graduate degree. Define semester. 12 semester units is too much. Should clarify JD must be earned at an institution that was accredited when the degree was awarded. Prior experience should expand to include hearing officer work for cities, counties, and states. And this one, building challenges and barriers for those not in large firms may negatively affect diversity and inclusivity. All right, those are all of the comments. Do you want to make any changes in the 24 hours of basic training or the 8 hours of basic arbitrator training or the definitions that we've given for JD, graduate degree, and conflict resolution certificate? Yes, Dr. Getz.
Yeah, just briefly, I didn't know if there was a meant distinction between number 10 under the 24 hours of basic arbitration, which is decision and award, and just ends there, as opposed to under the 8 hours, it says under 7, decision and award drafting. Is there any reason why we wouldn't have award drafting in number 10 above as well? I just don't know if that's a typo or what that was. Yeah, so
I
I
don't think
propose
that
it
was,
be in there.
I don't think that was an intentional distinction, but we have a couple members of the subgroup of the arbitrator group that was talking about that. Mr. Yamshan, you were actively involved in that. I think the concept was it was about drafting awards, right?
That's right.
Okay, great. Ms. Hudson.
Thank you. I am not sure what a regionally accredited law school is. That might just be my lack of familiarity. I've known of accredited generally, but I do think that the comment about accredited at the time the degree was earned is appropriate and a note that this group should consider. And I would also suggest, at least with respect to institutions issuing JDs, there are unaccredited, plenty of people who become members of the bar who attended unaccredited schools. They have the option of attending those schools and taking extra tests, the baby bar and all of that. So I'm really hesitant to exclude folks who chose to go to those institutions from from even being able to use this path.
Okay, thank you. All right, thank you, Mr. Weiner.
Does that reflect, Ms. Hodgson, is that what you were saying? Does that address what you were suggesting about at the time the degree was earned?
I think the same probably applies to the graduate degree as well, for what it's worth. But yes, it does address that point. Not so much the unaccredited baby bar takers.
Right.
That's a separate.
Yeah, let's take one piece at a time here.
Yes.
And I was wondering if Dr. Getz, might you be able to answer the question about regionally accredited? I'm just reflecting on your experience with accreditation.
Yeah, the accreditation landscape is changing a lot, so I'm not sure I have the expertise right now to tell you about that, particularly considering what's happening with the Department of Education. So let me just say that I don't think we'll be making any major errors by keeping the word regionally in there. But I agree with the group that this thing is very much in flux, given what's happened with the Department of Education and other institutions like that.
Okay, thank you, Dr. Getz. Ms. Copagan?
I'd also never heard the regionally accredited, so I looked it up. I agree with Dr. Getz's conclusion, but it does look like there is some kind of a regionally accredited only law school thing. So for what that's worth.
But just be sure, I can briefly speak to this if that'd be helpful.
Yeah.
Yeah, so there's something called the Western States Conference that accredit. Thank you, Shell. That accredits law schools in the Western states, as you may know. The State Bar has essentially very recently basically determined that Cal accredited schools will that there can be some symmetry between the requirements for those two groups. And so it could be helpful at some point, with the thought being that you don't want to have to change one set of rules when you change another set of rules, to have that regional item in there. To Dr. Getz's point, I don't think it's going to do any harm to have that information in there.
Okay, thank you. Mr. Yamshan?
Thank you. This is coming from a point of ignorance, I guess. Conflict resolution certificate. There may be a certificate in mediation. There may be a certificate in arbitration. Columbia Law School offers a certificate in international arbitration. It's rigorous. It's 40 hours plus homework, 40 hours on site. But so the conflict resolution certificate, would that include in any, I guess you might call it a subspecialty of conflict resolution?
If I may, so I think as it's written, it would have, I think the requirement is it needs to include at least 12 units covering conflict resolution theory and practice. So it may be a little bit broader than just a certificate in arbitration or international arbitration. I think when this was developed, what folks had in mind was conflict resolution certificates from the likes of some of the California State Universities, Dominguez Hills, Pepperdine has a conflict resolution certificate. I don't know if USC has a conflict resolution certificate, but I think those are sort of the general certificates in conflict resolutions, what I believe was contemplated when this recommendation was developed.
Thank you. And George Mason also offers a certificate program.
Okay, great. All right, I'm gonna look to see if there are any more hands. Okay, I don't see any. So you have our proposed changes. Okay, that's with the 24 hours. And then we jump down to JD. You see what the change suggested is? And graduate degree and conflict resolution certificate. Are those okay? Does anyone have any objections to those changes?
I see Ms. Hodgson's hand.
Okay, Ms. Hodgson?
Thank you. I remain concerned about the folks that attended unaccredited JD programs but did become members of the bar being entirely excluded.
So
if they're admitted to practice, if I may, then I don't think they need to qualify on they don't need to have qualified on the basis of a qualifying JD. it's if they're not admitted to practice, if they earned a JD and have not been admitted to practice, this definition would allow them to become certified if the institution that they received their JD from was accredited. But it wouldn't exclude anybody who was admitted to practice.
Just said a different way, I think what we're saying is that those who graduate from Cal unaccredited law schools and who did not pass the bar would not be able to become certified arbitrators under this path. There may be another path that they would qualify under, but not under this one in particular. Is that right, Alan?
Yes, exactly. Thanks for that clarification. They could still qualify by taking a 24-hour basic arbitration training, under path 1.
Okay.
Or
Thank
under
you for
path
that
3 if they have, the higher level of experience.
Oh, that's very good point. So they would not be left out.
Perfect. That was my concern. I appreciate the clarification.
Okay, good question. All right, so is there anything else regarding the changes that we've just made? If not,
Judge Pichon, can I
yes.
make a request and suggestion? If this would be a convenient time to take a break, on the break, I can prepare a resolution or revise the resolution to carve out the matters that are being reserved and sent for further study.
Absolutely. Would you like to take 15 minutes for that then?
I see Mr. Pulaski's hand if it.
Yeah, I just think if we're going to delegate stuff back, we need to define advanced arbitration training at some point.
Let me go.
We can do that in the committee.
Oh, wait.
It's in path 3.
Mr. Pulaski, I think the thought was that with the basic, it's advanced or continuing. And so I think the concept is that it's more than the basic that would satisfy it, and that it's a broader field that would satisfy it, sort of like the continuing education, doesn't really define exactly what qualifies as continuing, has some broad criteria.
Okay.
I don't know if that helps or not.
If you're good, I'm good.
Okay. All right, then we'll take a 15-minute break, and then we'll come back with a resolution for the group to vote on that will take care, if you do vote on it, that'll take care of Appendix A minus the definition of qualifying arbitrations. Okay.
Thank you.
All right, so we'll break until 3:45.
Thank you.
All right.
I will resume display of the appendix with the proposed resolution.
Thank you so much for doing that.
Of course. So for those for whom it may be small on screen, the proposed resolution is resolved that following notice and publication for informal public comment, the Alternative Dispute Resolution Working Group approves and recommends that the Board of Trustees adopt the Alternative Dispute Resolution oops, this is wrong. Yes, adopt the Alternative Dispute Resolution Certification Appendix A, I think. It's not the program rules. I'm going to start again. Approves and recommends that the Board of Trustees adopt the Alternative Dispute Resolution Certification Program Appendix A as published for comment, as amended during the working group meeting, with the exception of the definition and required number of qualifying arbitrations for each path and for recertification, which are referred for further study and recommendation by a new subgroup to be formed. And then this is the same document that we were making the track changes on throughout. So we have the changes from 2 to 3 years. And adding drafting here and changing the latest changes about an institution that was nationally, regionally, or state borough accredited at the time the degree or certificate was earned.
Thank you so much. Is anyone willing to make a motion? I'm sorry, Ms. Ellis, do I need to call for a motion? I do.
Yes,
Okay.
yes.
Is anyone willing to make a motion to approve this resolution?
Moved.
That Mr. Yanshan, thank you.
Yes, you're welcome.
Is there a second?
Second, Curtis?
Thank you, Ms. Curtis. There's a second. And Angela, would you please call the roll?
Armstrong is absent. Coulter,
Yes.
Curtis,
Yes.
Dinkin is absent. Dubois is absent. Ellis,
Yes.
Dr. Getz,
Yes.
Higuchi is absent. Hodgson,
Yes.
Kelly is absent. Kopakin,
Yes.
Cruz is absent. Lowe,
Abstain.
Judge Lucky is absent. Pulewski,
Yes.
Robertson,
Yes.
Tuckman,
Yes.
Welch,
Yes.
Yamshan,
Yes.
Judge Pichon. Judge Pichon.
Oh, I think, yeah.
Thank you. The motion carries.
Thank you very much. Great job, group. Great job. That wasn't easy. But I hope your sleeves are still rolled up because now we're going to move on to Appendix F. Appendix F is the proposed tiers structure for arbitrators. So we're finally going to work on one of the tiers. There were 48 narrative, the tentative recommendations in Appendix F. There were 9 people who commented. Many, if all, of the baseline requirements for arbitrators contained in Appendix F are also contained in Appendix A. Therefore, there is significant overlap between the provisions in and comments about these two appendices. If a substantially similar comment was made and discussed in connection with Appendix A, then I won't repeat it here. So to start, we'll start with training. And training consists of criteria numbers 1 through 4. The comments for these have been discussed in Appendix A. And based on those comments and our previous discussions, do you want to make any changes to criteria numbers 1, 2, 3, and 4? Okay, I don't see any hands. All right, then we'll move on. The next is experience. That's numbers 5 and 6. The comments concerning the experience requirements set forth in Appendix F, including those, concerning the definition of qualifying arbitration, have been discussed in Appendix A. So we're not going to work with qualifying arbitrations here, since we have sent that to subcommittee. Based on the comments that we've reviewed in our discussions, do you want to make any changes to criteria numbers 5 and 6? Okay, I don't see any hands. Okay, next is professional development. That's criteria numbers 7, 8, and 9. There's a lot to be said here. So the proposed tiers 7, 8, and 9 well, let me start with number 7. Proposed tiers criteria for arbitrators, number 7, pertains to recertification only and would require or provide elective credit for membership and participation in a professional membership organization that encourages ethics and professionalism in arbitration. Under the working group's tentative recommendations, criteria 7 would be inapplicable to baseline certification. It would be an elective in tier 2 and required in tier 3. A public comment was submitted that concerns the meaningfulness, lack of definition, and challenges in administering tiers credit for membership, participation, and leadership of an organization that encourages ethics and professionalism in arbitration. This person suggests that criteria 7 either be eliminated from the tier structure, or alternatively, that the State Bar maintains a current list of qualifying organizations on its website so that the practitioners do not guess wrong in choosing an organization that will satisfy these tier criteria. Staff believes that membership, participation, and leadership in organizations that encourages ethics and professionalism reflect and promote consumer protection. Staff thinks it will be relatively easy for practitioners and the State Bar to determine whether an organization satisfies these criteria, and that the universe of those that do is fairly small. Staff similarly think that practitioners and the State Bar will be able to determine what constitutes a leadership role. Staff would have concerns about the State Bar publishing a list of approved professional organizations on its website, as this might be deemed an endorsement of the organizations that are listed or a lack of endorsement of those that are not. However, the State Bar might reasonably provide a short description of characteristics it will consider in determining whether an organization satisfies these criteria, and of those that constitute a leadership role in an organization. Staff is necessary for to develop such descriptions, but will certainly consider the members' input on both. Staff do not think that enforcing or monitoring compliance with these tiers criteria will be burdensome. The certification program contemplates that members will attest to satisfying the relevant requirements. Staff assume that practitioners seeking certification will be truthful, and the proposed rules provide authority for the State Bar to audit compliance. All right, based on all of that, does the working group wish to make any changes? 7, 8, and
Dr. Getz's
see
hand
Dr.
is up.
Getz.
Thank you. Dr. Getz?
Thanks, Judge Bashan. I'm not feeling so strong about my advice that I would go against staff, but I just would ask staff to think about a couple of things in their comments. And again, reiterate that this is going to have to support itself, this certification. So you're going to want a certification that practitioner could look to and say, okay, this is how I get this certification. I will do this, or I'll join this, or whatever. Number 7 and number 22, without some list, leaves the practitioner in a real unique situation of, gee, I don't know if this organization qualifies or not. So what will the practitioner do? 1, they may call the State Bar and whatever contact number, or write an email and say, does this organization, so that will require staff at that point to decide whether or not they're going to give prejudgment on something, on an organization anyway. And maybe that's one way to handle it. Another way would be to put up a list and say, we do not endorse any of these organizations, but they would be considered an organization that encourages ethics and professionalism. Otherwise, it renders this meaningless. In other words, nobody can actually say with any certainty if they're not going to get a comment back from staff prior to certification, or there's no list. It leaves someone as really uncertain as to whether this qualifies for tiers or not qualifies for tiers. It puts staff in a really weird position if someone puts an organization on there and they decide, nah, that doesn't make it. They have to get back to presumably an otherwise qualified practitioner and tell them, nah, I know you volunteered for that or you did all that work, but we don't agree that that's an organization and we're not going to count it. It's going to put the state bar in a very odd position. So while I don't feel strong enough to say we ought to really reconsider 7 and 22, I would say I would ask staff to reconsider their position on this, because I think it's going to be a chilling effect on their membership levels, at least in relation to using 7 and 22. Thank you.
Thank you, Dr. Getz. Ms. Hudson.
Thank you. I just wanted to support staff's recommendation here as the prior ADR director of a court program with qualifications to join our panel. I have received similar feedback and similar concerns as far as how do I know if the training that I'm trying to sign up for qualifies, et cetera, et cetera. The way that I approached it at the time that I was the director, and that may be worth this group considering, is rather than setting forth a list of organizations or groups, both because ethically it avoids the possibility of endorsement, but it also avoids the possibility of constantly updating that list every time a new organization or group either disbands or forms, is to create sort of a list of, or like a checklist of ways in which a group might satisfy this idea or this concept. So you're not saying, this group, this group, this group, yes, this group, no. For anyone who does any sort of legislative interpretation, we also avoid this idea or this notion of, if there's a list of things and my organization isn't on it, it must de facto mean that my organization didn't pass the state bar's muster for this, and I don't think that would be the intention at all. So instead, I would create or suggest we brainstorm a checklist of things that would be hallmarks of a professional membership organization that encourages ethics, da 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 da. And I'm not saying that's a fun activity. I'm not saying it's a simple activity, but I think it avoids the ethical challenge.
Thank you, Ms. Hudson. Mr. Weiner?
Yes, thanks. I feel like, is it Justice Potter who had the challenge with defining confidentiality? And I think we need not spend too much time trying to figure out what really constitutes an organization that supports professionalism and ethics. For example, an organization that provides ethics training would presumably do that. An organization that has an ethics hotline would probably do that. And I think there are a variety of other ways. I just don't think it's as hard to apply in actuality as it might be to try and define it. As the staff comment said, we would welcome, ideas from, and as Ms. Hodgson said, ideas from the working group about, sort of what's the list of criteria. I just don't feel like it's going to be the challenge that, with all my respect for Dr. Getz, that he foresees.
All right. Thank you, Mr. Weiner. Is there anyone else? All right. I don't see any other hands. All right. So based on our discussion, does anyone wish to make any changes to professional development criteria 7, 8, and 9? Okay, thank you. That's a great discussion. So next we'll move on to ethics criteria numbers 10, 11, and 12. Comments were: what is an organization that encourages ethics and professionalism? Need a definition for this. The state bar would be better off to eliminate this from the tiers, or alternatively, maintain.
Excuse me, Judge Pichon. I'm sorry to interrupt. I think those are the comments that related to the previous one about membership in an organization that promotes ethics. These 10, 11, and 12 refer to training training received in ethics.
Training. Well, I took it from there, so maybe that's fine. Yeah, no, you're right. Okay, scratch that. So the next one, a comment would be, it should be made clear what ethics training would qualify for this requirement. That's where they fell. Okay, if they don't apply, that's fine. The next is, will the state bar be determining qualifying professional membership organizations? That's all that I pulled out from ethics. But I do have the response list here, and I'll see if that's incorrect. I'm going to ask staff, do you have any other comments under ethics?
I don't readily see any that that I categorized as coming under those headings. I think there were maybe some general comments about the state bar should offer them. And I think that sort of came up when you were talking about training in general. And I'm sorry if I have made the screen share disappear.
I've pulled my response chart up, and I'm going to F.
Well, let me make this observation about 10, 11, and 12. So 10, these were comply with the statutory and ethical requirements for arbitrators. It was sort of, there wasn't really so much discretion or discussion to be had about this. There's the baseline training requirements regarding number 11, and the view of the working group in developing the proposal for comment was that if somebody did additional arbitrator ethics training, an hour more than what the requirement for baseline was. So I think we have 2 hours during what's now a 3-year period required for baseline ethics training. So if they did 1 more hour of training, if they did 3 hours during the 3-year period, that would be required for tiers 2 and 3. And if they did 2 more hours, that would get them into tier 3. So I don't recall any comments about that didn't come up under sort of the baseline ethical training requirements, which were already discussed and voted on by this group.
Okay, and I'm looking at it. I don't see anything except under recertification app. Okay. So unless someone is aware of a comment that I did not see for ethics, would you please let me know? And if not, based on what you've read in your homework, do you want to make any changes to numbers think it was at 10, 11, and 12.
10, 11, and 12. Yeah, if I may, Judge Bishan, I'm seeing sort of an issue with the change that the working group made with changing the period of time during which that ethics training needed to occur from 2 years to 3 years. It used to be 2 hours during a 2 year period. And now it's being recommended 2 hours during a 3 year period. So that's going to change it's going to change this 2 hour total. If we took this out, it would still work.
Okay, so the
Well,
change,
it's a problem because the 2 years was, the 2 hours was equally divisible by the 2 years. And so it was 1 hour per year. And when we said, one more hour, that gave a 2 year total during each year. I started to speak over somebody. Was that Ms. Doherty or somebody else?
I think you could strike year of the and just say during each recertification period to simplify things.
So now you would be cutting the number of, in addition to cutting the number of hours of training required for baseline, you'd be cutting the number of hours required, changing it from 1 hour more per year to 1 hour more per 3 years. That's a pretty watered down result.
Oh, I follow. I see what you're saying, Ellen.
then what is wrong with, since this doesn't contain any years, 10, 11, and 12? Do you feel that a change needs to be made, says during each year of the recertification period?
I guess, yeah, I think somebody had mentioned just cutting the 2 hours total in parens. Yeah. That seems to work.
Oh, I see. Yeah. How does the group feel about that?
I think maybe if we say, basically 1 more hour than required during each year of the recertification period, I think staff can probably wrestle with the math on that in kind of finalizing this for implementation. Does that?
I have no objections.
Okay.
Is that the
Okay,
same
should-
for 12 though? It's because that says 3 hours.
Yeah, first of all, this should not have this. It should be 2 more hours of arbitrator ethics training than the same thing than required. How does that look?
Did I go away?
If no one is,
Oh, wait, I thought I lost you. Now I don't know where you are.
oh, I'm sorry. So I think we were asking
No, I'm
if,
fine. I just can't see you all.
so I don't see any hands up in response to your question about whether everybody was okay with 10, 11, or with 11 and 12 as revised.
Okay. Oh my God. Okay, just give me a minute. I gotta find you all. I don't know where your picture is.
Oh,
Yeah, well, you're lost.
do you
Okay,
see anyone's picture, Judge Bishan, or
nobody.
Do you see the screen?
No, I don't see anything.
Fine, back on.
do you want us to take a pause and you,
Oh, yeah, could you?
I hear you and I see you, but you
Oh,
should see us.
For a second, just for a
Okay.
second. I may
We'll
have
take-
to go here somewhere, but I don't know where that is. Okay, gotcha.
You find us?
Yes.
Great. And are you seeing the shared screen also?
Yes, I am. Yes.
Okay, so here's where we were on 10, 11, and 12 with these revisions here. And if
Okay.
I read the room correctly, I think everybody was saying they were okay moving on.
So, yes, are there any objections to the changes that we've made to 10, 11, and 12? Okay, wonderful. Then we'll move on to number 13, that's maintaining participant records. The one comment I saw said this was burdensome. Did you see anything else related to number 13? Okay, any changes to be made to 13?
Only the grammar. The
Okay,
the period of 5 years means you should keep the records for 5 years, not after you were certified for 5 years. Just move
Yeah,
the
that
period.
I agree that it can be clarified. I think the intention here was that you need to begin keeping the records when you become certified, because otherwise there's sort of like a 5-year waiting period if somebody hasn't kept the records before they could become certified.
I agree. It should just,
What if you start it with upon becoming certified, practitioner keeps records, et cetera, et cetera?
after becoming certified. Right?
Yeah.
Was that the suggestion? Was that Ms. Hodgson? Was you? Yeah.
Yes, that was me. And yes, that's the suggestion. Thank you.
Does anyone have any objections? I'm looking for hands. I don't see any. Okay, great. We'll move on. Next, we have disclosures and recusal. That's 14 through 18. And I hope I have the comments correct. They are, this provision is very problematic, could cause delays and objection issues and make compliance very difficult for larger professional provider organizations. Under the proposal, a Tier 3 arbitrator cannot accept overlapping appointments unless parties consent to this practice prior to the appointment of the arbitrator. However, parties rarely, if ever, discuss this issue before appointment. This requirement should be removed altogether or made elective for Tier 3. The next, number 16, is a requirement for Tier 3 and will deter experienced arbitrators from seeking certification because Tier 1 and 2 certification is far less prestigious than Tier 3 certification. There are certain fields where the number of law firms that have expertise are limited, and so it is not uncommon to have more than one pending case with a particular law firm. The current procedure, where an arbitrator states at the outset that the arbitrator will accept new business and the parties have an opportunity to preemptorily challenge the arbitrator if they disagree with the policy, is more practical. Number 17, the 5-day requirement could be problematic. Possibly allow more days or at a minimum change to business days instead of implied calendar days. Number 18, even though this requirement is an elective, it is unnecessary. Arbitrators are normally selected because of their expertise in the subject matter of the dispute. The parties are normally aware of such expertise because it is probably contained in the arbitrator's resume. 19, what does facilitate mean? Those are the comments. Would the group like to make any changes based on those comments?
If I can just make a comment on, these were very, there was a lot of thought given to these by the working group in coming up with the comments, in particular, the one about declining to enter new relationships unless the parties agreed to that before. That was a particularly carefully crafted compromise, so that the parties would be able to, if they wish to select somebody because they knew that person was in Tier 3, and that meant that they wouldn't agree to accept new cases from a party in a pending case unless they agreed to. So I think these 5 or 6 tiers criteria are again especially well thought out, and also some of the reasoning behind them wouldn't have been apparent to folks who were reading for the first time and commenting on them. So say that.
Okay, thank you for that comment. Is there anything else? Would anyone like to change any of the language based on the comments? Okay, I'm looking. I don't see any hands. All right, very good. We'll move on. Next is advancing the field. Those are criteria numbers 19 through 22, although I already read your comment on 19. The comments for 19 through 22 are 19. This may be impractical given the time commitment and number of practitioners in the state. For paragraph 22, what is an organization that encourages ethics and professionalism? Without a definition for this, it becomes a very arbitrary standard, not conducive to a statewide certification program. Practitioners could join an organization thinking that it encourages ethics and professionalism and find out later that the state bar thinks differently. And so it goes on to talking about maintaining a list, so I won't repeat that. Number 22, what's a leadership role? And what does that mean that every member of a professional membership organization, as noted, will have a title? Who determines what leadership is? Also for number 22, what determines what professional membership organizations qualify? and then what constitutes, as I read before, a leadership style. Under additional comments, I'll just include it here, is recognition of multi-member panel service. Regarding Tier 3 qualifications for arbitrators, this person advocates for the formal recognition of multi-member panel service. All right.
I'm sorry, multi-member what?
Panel. That means being on
Okay,
a panel with three.
yeah, I know that, okay.
I was trying to think of the formal label for it. Okay, so are there any changes?
If I can just make an observation, Judge Bashan. So number 22 about serving in a leadership role in a professional membership organization,
Right.
that's sort of the counterpart to the previous one, number 7, being a member in it. So I think the issues about
Yeah.
what is a professional organization, as you noted, have kind of been spoken to about above. The ones about what is a leader, I think haven't been spoken to, but again, I think that's something that the state bar will be able to wrestle with.
Okay. Okay, anything from the group for the last, that was 19 through 22, anything? And if there are any additional comments. Okay, seeing
I'll
none.
also note that 19 and 20 are where the previous discussion about receiving credit for providing the trainings. This is where that appears
yeah.
in the tiers.
Thank you for pointing that out. Yes. Okay, I'm not seeing any hands. Did we actually make any changes?
We did make just a couple.
So do you need time to draft a resolution for F?
I think we can do this more quickly. Yes. Bear with me 1 minute and we may have it for you. So this resolution reads, resolved that following notice and publication for informal public comment, the Alternative Dispute Resolution Working Group approves and recommends that the Board of Trustees adopt the Alternative Dispute Resolution Certification Program recommendations published for comment as Appendix F as amended during the working group meeting. So that would be the resolution that would be voted on, or that's the proposed resolution to be voted on.
Thank you very much for doing that. Is anyone willing to make a motion to approve? Mr. Poleski, thank you. Is there a second? No second? Is that because you disagree? Or
Curtis, I'll second it.
thank you, Ms. Curtis. Angela, would you please call the roll?
Armstrong is absent. Coulter,
Yes.
Curtis,
Yes.
Dinkin is absent. Dubois is absent. Ellis,
Abstain.
Dr. Getz,
Abstain.
Higuchi is absent. Hodgson,
Yes.
Kelly is absent. Kopakin is absent. Cruz is absent. Lowe,
Abstain.
Judge Lucky is absent. Palevsky,
Yes.
Robertson,
Yes.
Tuckman,
Same.
Welch,
Yes.
Yamshawn,
Yes.
Judge Pichon.
Yes.
The motion carries.
Okay, the motion carried, but I'm not sure what the issue is. Is that something we needed to discuss? I guess I won't know. I saw you.
Mr. Tuckman's hand is up.
Is that things?
Yeah, just to explain, the issue regarding arbitrators and the need to get the consent of both parties for the tier 3, is potentially, I think, problematic. So that's the reason I'm abstaining. There doesn't seem to be tremendous opposition to that, but I'm just sharing with you my thinking.
Well, thank you. I appreciate it. Anybody else? Okay. Well, thank you. That does take care of Appendix F. If you're ready, we'll go on to Appendix C. And Appendix C is the proposed qualification requirements for provider organizations. The first one is provider organization, the definition, and it means an entity, firm, or association that, or an individual who offers, coordinates, administers, or provides the ADR services of 2 or more practitioners. The comment was that organizations who provide community mediation, parentheses, low cost or free, in parentheses, and or who have a contract with a county to provide mediation for court-referred cases should be exempt from these provider organization requirements. That's all I have under provider organizations. Does anyone wish to change the definition?
Judge Pichon, if I can just make a brief comment. So I would say that there's no need to exempt organizations because certification is voluntary. If one of those organizations doesn't want to become certified, there's nothing that requires them to. And if they do, the structure allows them to.
All right. Does anyone else want to comment on provider organization definition? Okay, next, then we go down to D, 3D, which is have administered at least 2 times the minimum number of dispute resolution processes in California as required for certification as a practitioner of the processes it administered. And the comment is that the requirement of 2 times should be changed to 4 times. Based on that, would anyone like to make a change? Okay. Seeing none, we'll move on. The next one is E3. Designate 1 or more ADR process experts, resources who are familiar with the ADR processes administered by the provider organization and can answer questions about the same. And a comment, should the working group further define staffing to make it clear whether a person can serve in multiple roles? Can the same person serve in more than one role? This would reduce the burden of this requirement.
If I may, Judge Pichon, that was the intention of this as it was drafted by the subgroup, and that issue was specifically discussed. In several places we have, or here we have 1 or more. The idea was that if it wasn't one person who had the ability for all of the processes. It could be multiple people, but I think the implied corollary to that is if one person can do all of the processes, that's a lot would be allowable under this structure.
Alan, did you mean to share your screen? Maybe I don't.
Am I not sharing it?
Do you guys?
Sorry.
Okay. Thank you.
I'm scrolling and highlighting, so you can't see it. You still can't. How about now?
Yes.
Thank you.
Thanks for letting me know.
Okay. So that is E3. And I don't know if you want me to read the comment again, or is everybody fine with it? Well, based on that comment, does anyone want to make any changes to E3? Okay. All right, then we'll move on to F. F is all case administrators and marketing staff receive 1 hour of training in the State Bar ethical standards relevant to their areas of work during each of the provider organizations' recertification periods. And there were 3 commenters who agreed with this provision. 1 agreed only if modified, and 2 submitted narrative comments. Both narrative comments asked whether this meant, and in one case, why marketing staff would need to receive training in marketing. 1 asked why this would apply to all marketing staff or only to those who work in or on California business. Would anyone like to make a change to F based on those comments? I don't see any hands, so.
I see Mr. Tuckman.
Mr. Tuckman.
Again, this is a provision that had some discussion, but I'll just emphasize the need for, if you're thinking about larger nationwide or international institutions, there are large numbers of case management staff who don't touch anything related to a California arbitration. So I do think that some sort of boxing this in does seem like an appropriate change. So I do agree with that comment.
With the comment?
Yeah, with the comment that there's no limitation to requiring training of all case management and marketing staff to those who are working on cases that might have something to do with California law, California location, administrating California. Those are all appropriate. I understand the intent of it, but there are, again, many other staff that just don't have any connection to a California case. As it's written currently, they'd be required to, engage in the training.
Okay. Would the change that Mr. Weiner is typing in satisfy your concern?
Yeah, I'm wondering if there's that does cover it, but we've bumped up against this issue, trying to define the scope of the certification standards and cases, and I'm wondering if there's language that we've used before that works.
Well, that's an area yet to be discussed. That definition is in the ethical standards for certified provider organizations, and that's why I sort of referenced it here.
Okay, all right.
We will be discussing it there, and however that's resolved would be incorporated here.
Okay. Great. So yeah, I'm thinking the same way. That works.
Okay, I saw Mr. Palevsky. Was it your hand up?
Yeah. I understand the concern. Marketing staff don't handle cases. And marketing is oftentimes done on a national basis, so I'm not exactly, I think I'm trying to accommodate Eric's point, but I'm not sure that marketing staff handle cases or how to distinguish marketing staff that are marketing to national corporations, how that fits into that.
Okay, so then Mr. Palevsky, what would your suggestion be?
I think when Alan was almost there.
I just put it in the wrong place, I think. I don't know, it's not very eloquent. Market business.
May apply.
Market to businesses. But the ethical standards don't apply to the businesses.
Oh, market services. I think the would apply in the marketing, it probably should be may, because you don't know in advance exactly which companies are gonna have California applications.
Okay, Mr. Tuckman, how's that with you?
I'm actually I'm less concerned about the marketing. Just one thought, actually, all case managers and marketing staff who administer cases, maybe instead of handle.
Okay, all right, we'll try that. And I see Mr. Yamshan's hand up.
Thank you. This is kind of an arcane question, and I'm not sure that it actually raises a problem. But if you have a national provider that decides to get certified in California, and you have an interstate case, and one of the parties is in California, but everyone else is in other states, I'm wondering, and the case was filed in a different state, then I'm wondering how this would apply. And maybe it's a ridiculous question and it doesn't create a problem at all.
Yeah, if I may, I think it's something that would be addressed to Mr. Tuckman's earlier point when we discuss the applicability of the ethical standards. I think there are a couple of different approaches there. There's a working group tentative recommendation and an alternative staff recommendation. And so I think by tying it here to cases to which the standards apply or marketing services to which the standards may apply, I think the application provision of those standards will address the issue, which I think is not unduly arcane.
Okay, thank you.
All right. Any other hands? Okay. I don't see any. All right, with the language changed as it is in F, is there any objection? Okay, hearing none. The next comments fall under H. H is have procedures to remedy its California-based is in parentheses. So I'll read it again. Require all its California-based affiliated practitioners. I'm sorry, that's wrong. H is have procedures to remedy its California-based affiliated practitioners' failures to comply with the applicable ethical standards. And the comments were 2 agreed, if modified, 1 agreed, and 2 had no position. The 3 submitted narrative comments were that the provider, organizations, and staff administering these requirements need a clear definition of the requirement to have a remedy procedure, and that a practical definition of the requirement to have a remedy procedure is needed. And then the third focused on complaint procedures, including due process, fairness, and confidentiality and consideration. Based on these, would you like to make any changes to paragraph H?
Judge Pichon, if I can just provide a little context here and maybe raise a concern, I'm not sure. So the statute says that firms, providers, and practitioners need to have a procedure to remedy. The working group and the legislature, potentially by SB 574, are saying that the complaint procedures have to be handled, by the state bar or designated organization. The working group hasn't really discussed what a remedy means, what hasn't interpreted, if you will, what is the remedy requirement of Section 6173. So does that mean, an easy case might be if somebody has a complaint that a practitioner overbilled, then an easy remedy to find might be to refund some fees. But given the range of possible ethical violations, I'm not entirely clear how we might say more specifically that they need to have a procedure to remedy, as the statute says. Sort of specifically what the remedy needs to be. It sort of seems like the provider organization needs to take into consideration the nature of any violation that's found, and determine what's appropriate, just like the state bar is going to need to do with its complaint procedures. Is removal of the or disaffiliation of the practitioner the appropriate remedy? Is requiring additional training? Is refunding some fees? Those are the questions that the comments about what is a remedy procedure raise for me.
Is overbilling an ethical violation?
I would think so.
I think there's something about the reasonableness of billing, or at least billing in accordance with the agreement, right? So I probably muddied the water.
No, the question is, do you want to keep H? Or do you want to rewrite that?
Well,
Mr. Yanshan's hand is up.
okay. Thank you. I can understand the commentator's concern, and one of the problems we face is it's very difficult to come up with precision that will fit all situations. one thing to overbill, it's another thing to have an inadvertent ex parte communication with counsel. If there's other potential breaches that range from minor to major, and I think that we have to give the providers a certain amount of leeway to determine the remedy, whether it's dislisting or unlisting the neutral to a talk with a vice president or something. So the comment was basically, as I understood it, that we need to give this more substance, but I'm not sure how we can while allowing the providers the versatility they need.
Okay. All right.
I've made a suggestion here. I would just add to what Mr. Yamshine has said. The other aspect of the problem that we have is the statutory requirement that provider organizations have such a remedy process, right? So I think if we just eliminate it, the state bar could be certifying providers that are not in compliance with the statutory obligation.
All right, Mr. Weiner, does that mean you're happy with what you've written there, striking out the word remedy?
I think, and substituting appropriately address, and I see Miss Jenna Ellis has her hand up.
Oh, I just had up the language from SB 574, and I know we largely tracked what's in current Cal Business and Professions Code 6173, but I'm not seeing it in the proposed amendments through SB 574. So I think to the extent it's someday eliminated from the statute, then maybe striking this provision wouldn't be problematic. But I don't know, just a thought on that.
Okay. Anyone else? All right. So it looks like where we stand now is either for H, we choose what's written here, or there's also the suggestion that H be eliminated. So does anyone have a position regarding accepting what's written?
I
Yeah.
think, go ahead, Cliff.
No, I just meant I accept what Alan has done.
Okay.
Yeah, I think he's done a good job. I mean, I wouldn't be offended if we eliminate it, but I'm comfortable with it.
Is there anyone who is not comfortable with keeping H as it's written? Okay. All right, then we'll move on. Looks like it takes us to J2-4. J2-4 is an explanation. Well, it's under to maintain a website that. Okay, and then it goes to J2, provides clear, accurate, and understandable information about the provider organization's state bar certification status, including, this is 4, an explanation that certification of the provider organization does not signify certification of its affiliated practitioners, and information about where on the organization's website the certification status of its affiliated practitioners can be ascertained. The comment is, it seems overreaching to list the names of mediators on a volunteer mediator panel who are not certified on a public website. Maybe just list certified mediators.
So I think we talked about this a little bit. This was actually kind of in the provider organization subgroup, there was a discussion under the ethical standards of the information that needs to be on the provider organization's website. And that was sort of copied over to the requirements for certification of provider organizations. I think the idea when it was discussed in that context was that the public should be able to tell whether the status of really all of its certified provider organizations. It didn't say that you have to have a list of the uncertified provider organizations, but if there is, I think there was discussion about there would probably be a short bio, at least, if not a full CV for the affiliated practitioners, and that could indicate whether a particular practitioner was certified or not. That's my recollection anyhow. Maybe the lead or members of that subgroup can amplify or validate that.
No. I don't see any hands.
I see Mr. Tuckman.
Mr. Tuckman.
As I'm recalling, the State Bar will be listing all of the certified practitioners and providers, right?
Yes.
I just wonder, I think that how providers provide this information and where they provide it, I think is going to differ. I just wonder if it might be better to say an explanation that certification provider does not signify, oh, that's fine. And information about where, yeah, exactly. The certification status of its affiliate practitioners can be ascertained. Deleting on the organization's website, I think, takes care of a little bit of my concern.
Okay, so the way it's
Because it might, I'm sorry, because it might be that institutions direct parties to the State Bar website. Some providers will list it on their website. Some might have it on, it's going to be on the resumes. I just think there's going to be different ways in which this is carried out. I think that removing the language on the organization's website takes care of it.
Hey, honey.
I heard a voice. Let's see. I don't see the hand.
I think somebody may have been made an offline remark.
Oh, okay. Okay. All right. Anybody?
And now I see Dr. Getz's hand.
Dr. Getz.
Yeah, I appreciate what Mr. Tuckman was trying to address, but I have concerns once you eliminate or take the burden away from the organization that it might be impossible or impractical for the consumer to actually find the information. In other words, yes, it could say you can find it on the individual practitioner's website, and it may or may not be there. It becomes really hard for a consumer who's relying upon a certification to really understand how many loops they have to go through to find out about somebody. So I just have concerns. Once we eliminate it from here, I see okay.
So it keeps the onus on the provider organization. So you're not sending the consumer on a scavenger hunt to find the information, and the provider organization can say, call us up at this number, ask your case manager, look on the website, on our website on this page, whatever their preferred way of providing that information might be. Would that help you, and would that still be?
That helps me, thank you.
Would that be acceptable to addressing your concern, Mr. Tuckman?
Yeah, it's fine.
Great.
Just the additional language is fine.
Okay, anyone else? Does anyone disagree with the language in number 4? Is there any objection to it? Okay. That takes us down to number 3. That would be the definition of California-based panelist. We have said it means an ADR practitioner on a provider organization's panel or roster who resides or has a place of business in California. There was agreement with the definition by 3. 1 agreed if modified, 1 disagreed, and 2 had no position. The commenter who disagreed thought the requirement should apply to all affiliated practitioner, not only those in California. I don't know if staff wants me to share, or I think the comments are included in the comments. So staff notes some inconsistency in the use of the term practitioner and panelist. Paragraph 2 defines affiliated practitioner. Paragraph 3G to I refers to California-based affiliated practitioners. So it's the use of the word practitioner and panelist that is being used interchangeably, and perhaps that shouldn't be done. Staff also recommends that the word panelist be changed to practitioner. And then where I've been reading and saying that California based is in brackets, yes, that the working group decide whether to include California based or not in its recommendation or remove it.
Thanks, Judge Bashan. If I can just comment on that last piece. So the arbitrator subgroup and to some extent the provider organization subgroup struggled with the fact that the statute doesn't specifically limit itself when it says a provider organization needs to do this, that, and the other thing with respect to its practitioners. It doesn't specifically say with respect to its California-based practitioners or practitioners who have something to do with California. And so the statute would seem to apply very broadly. The subgroup did not think that the legislature intended the statute to apply that broadly, and so adopted this practice of putting California-based in brackets, but wasn't completely comfortable limiting the application of the rules to, in that way, since it wasn't limited that way in the statute. Mr. Tuckman, you were a predominant thinker on this subject. Do you want to add to or correct what I've sort of related?
Let me apologize first. I have another conference I have to attend. I'm already a little late. But I'll see you all next time, and thank you for your hard work.
Oh, thank you.
Thank you.
If
You're
I
welcome.
may, I apologize, Judge Sean. I do note it's 5 o'clock. It's slightly after 5, and the meeting's till 5. We are meeting tomorrow. We could break now if it's appropriate, and then pick up with California based tomorrow at 2.
That's fine. I thought I didn't realize it was 5. Thank you. Yes, we can certainly take that up tomorrow on the definition of California based. Okay. Well, everyone, we've really done a tremendous amount of work today, and it is truly appreciated. And I don't want to keep you a minute longer, since I will see you tomorrow at 2 o'clock. And tomorrow at 2, we'll start with this, and then move on to E and what's in the email that you received from us. So Oh, here it is. Oops. Okay, so that tomorrow we have E, H, I, J. Okay. Well, everyone, I have a good night's sleep and we're gonna roll up our sleeves again tomorrow.
Bye-bye.
Thank you.
Thanks,
you.
everyone.